Solomon Garrett was 40 years old when his wife called the police on him, and the two officers who arrived at his front door that evening had no idea that the building they reported to every morning had his signature on the deed. He answered the door in a dress shirt and house slippers, a glass of water in one hand, as composed as a man who had been expecting a different kind of knock. Officers Paulson and Okafor stood on the porch with the careful professionalism of officers responding to a call they had already assessed as uncertain. They asked for his name, confirmed the address, and asked if everything was all right. Solomon said his name was Solomon Garrett, that everything was fine, and that they were welcome to step onto the porch. His wife, Angela, stood in the hallway behind him. She had placed the 911 call 18 minutes before, telling the dispatcher that her husband was acting erratically and that she felt unsafe. She had her arms folded and the composed expression of a woman who had made a careful calculation and was waiting for it to produce the intended result. She had been planning this move with the attorney she had been involved with for 10 months, for most of the preceding year. The strategy was to manufacture a documented incident that would support an emergency protective order. Removing Solomon from the marital home before any divorce filing and triggering asset provisions she believed would accelerate her access to the estate. The estate, as structured through Solomon's firm and the prenuptial agreement executed before their marriage, was worth considerably more than she had been told. What Angela had never once thought to ask, not in 8 years, was whose name was on the deed of the building her husband drove past every time he went downtown. The 4th Precinct building had been leased through the Garrett Law Group for $2.3 million. What happened on that porch in the next 6 minutes ended her strategy entirely. Before we jump into the story, comment where in the world you are watching from, and subscribe, because tomorrow's story is one you need to hear. The morning light came through the east window of Solomon's home office the way it always had, direct and unhurried, settling across the surface of his grandfather's oak desk in a pattern he had long since stopped consciously noting. He had moved that desk from his grandfather's practice when Ezra Garrett died, carried it up 2 flights of stairs himself, and placed it in this room because certain objects carry weight beyond their dimensions and deserve to remain useful. His grandfather had practiced commercial real estate law in Memphis for 38 years. He had not been a wealthy man in the visible sense. 3 suits in rotation, a modest office on South Main Street that he never upgraded past what the work required, a used car he maintained well. But he had understood property the way very few people understood it, as the primary language that every other kind of power eventually had to speak. He used to say, in the unhurried voice of a man who had never needed to announce himself before the work did it, "The man who holds the deed holds the conversation. Everything else is just noise." Solomon had spent his career building that understanding into practice. The Garrett Law Group managed 31 commercial real estate properties across the Memphis metro through a combination of direct ownership and long-term institutional leases. Municipal clients included 3 city agencies, a school district, and, for the past 7 years, the building on the corner of South Bellevue and Macklemore that housed the Memphis Police Department's 4th Precinct. The lease renewal and capital improvement authorization for that property sat in a manila folder at the corner of his grandfather's desk, held together with a binder clip, waiting for his signature for 3 weeks now. He kept meaning to execute it. He kept finding other work to attend to first. On the wall beside the window, 3 framed property surveys hung in the order the firm had first acquired them, the earliest hand-drawn, the others printed, each one a record of something real and documented and bound in law. His grandfather had done the same thing at the South Main office. Solomon had kept the practice because it reminded him that what the firm held was not abstract value, but specific ground. Documents made permanent what a handshake only promised. He and Angela had been married 8 years. They met at a commercial closing. She had been the seller's agent on a midtown property, organized and precise, with the quality of attention that serious professionals carry into every transaction. He had been drawn to that precision. The first 4 years had been good and honest. In the 5th year she had begun, quietly and without announcement, to hold the visible shape of their life against a standard she had developed elsewhere, and to find the comparison increasingly difficult to accept without expressing it. He had attributed this to ambition. He had been wrong about what it was. His secondary phone, registered to the firm's managing partner address, used only for client communications requiring a separate line, stayed in the inner pocket of his jacket on the hook behind the office door. Angela had never asked about it. In 8 years of marriage, she had never asked about the full scope of what the firm managed. He had come to understand that the reason for this was not in curiosity, but assumption. The assumption that what he had was already less than she required. That first Tuesday in March, he sat at his grandfather's desk, reviewing a portfolio summary in the early morning and listening to the sounds of the house, with the specific attentiveness of someone who knows a building's usual rhythms well enough to hear when they have changed. The house felt different that morning. He could not have said exactly why. He had learned, over years of legal work, to give that kind of instinct its proper weight, without rushing to name it. He walked to the kitchen to refill his coffee. On his way back, he passed the hallway printer. The output tray held more pages than he had sent to print. He stopped. He picked them up. He came back to the printer after confirming they were not his, and stood in the hallway with 7 pages in his hand and read. The emails were between Angela and a man named Blake Corrigan, a family law attorney with a practice in East Memphis, known to Solomon professionally by reputation. The early messages in the chain were personal in the way that certain correspondence becomes personal when the formal register people start with gets quietly set aside. The later ones were strategic. He read through the chain twice, standing in the hallway in the morning light, and then he carried the pages to his grandfather's desk, laid them flat, and photographed each one methodically with his phone. His hands did not shake. His face remained perfectly calm. What the emails documented was 10 months of involvement between Angela and Blake Corrigan, and 4 months of legal planning for a divorce, proceeding that Blake had been developing on her behalf. The strategy was specific and multi-step. It included, in Blake's own language, a proposal to manufacture an incident sufficient to support an emergency protective order, a documented measure designed to remove Solomon from the marital home before formal papers were served, creating a record that would shape the asset division. The word manufacture was theirs, not his. It appeared in the 4th email, unambiguously, in a paragraph that laid out the tactical sequence with the specificity of a man who understood the legal mechanism well and intended to use it. Solomon set the pages in a neat stack. He moved with the same deliberate calm that had defined everything he had ever done that mattered. He spent the next 4 evenings at his grandfather's desk after Angela had gone to sleep, building the documented record the way he built every case assessment, starting at the perimeter and working inward, without reaching for a conclusion before the evidence required one. 5 months of joint account statements, downloaded through the secure portal and printed in order. 4 transfers to a personal account she had opened without his knowledge, totaling $28,600 across 11 months, executed in amounts carefully below the threshold that triggered automatic account notifications, which told him something about who had advised the structure. A hotel charge in Germantown on a date she had described as a professional development seminar. 2 cash withdrawals on consecutive Saturdays in October. A wire transfer in September to an account number that appeared in none of the joint records he could access, on a weekend he had spent in Nashville at a property closing, and she had said she was at her sister's. He built a cross-reference timeline in a separate column, her stated schedule alongside the documented charges. The two columns aligned at every point that mattered. The picture that produced was not ambiguous. He also pulled Blake Corrigan's public disciplinary record from the Tennessee Board of Professional Responsibility. A prior complaint had been filed in 2021 by a former client alleging misrepresentation in a settlement negotiation. The matter had been closed with a private admonition. It had never been resolved through a formal hearing. The admonition was noted in his public record, which he appeared not to have considered when he put the word manufacture in a written communication with a current client. That was, Solomon thought, the specific quality of a man who had operated just beneath consequences for long enough to believe he always would. He organized everything onto a yellow legal pad in the format of a preliminary brief, not because it would serve as one, but because that was the instrument he trusted. On the fifth evening, he closed the pad and picked up his phone. He called Priscilla Owens. She answered on the second ring. "I need you in the office tomorrow at 7:30, he said. "I have a matter that belongs to the firm." "I'll be there," she said. The deed held the conversation. He was ready to have it. Priscilla Owens had been Solomon's partner at the Garrett Law Group for 14 years. A woman of 60 who reviewed documentation with the forensic efficiency of someone who had been doing it long enough to have lost all patience for anything other than what the evidence actually said. She spread the pages across the conference table in her corner office and read through them without speaking for 40 minutes. Then, she turned the last page over. "He used the word manufacture in a client communication," she said. Page 4. Solomon confirmed. "That is not a strategic error," she said. "That is a bar complaint written by the person making it." She looked at Solomon over her reading glasses. The prior admonition compounds it. A pattern of conduct allegation becomes available to us. She set the folder down. "The prenuptial agreement is clean. Your firm holdings and the trust assets are fully protected. She is entitled to the marital home and the structured settlement amount specified in the agreement. Nothing beyond that." She paused. "Do you want to move now or wait for her to file first?" "I want to be ready when she moves," Solomon said. "Not before." Priscilla nodded once, the specific nod of a person who has heard the right answer and does not need to say so. Some things you don't announce until the room is fully prepared to receive them. 3 days later, Solomon drove to the east side of the city to see his uncle, Harold Garrett, his grandfather Ezra's younger brother, a retired circuit court judge who had sat on the Shelby County bench for 22 years and who received information about other people's legal situations the way a retired general received reports, with interest, without surprise, and with immediate instinct for what it meant. Harold listened from his chair in the front room with his eyes on the middle distance, asking nothing until Solomon had finished. Then he said, "Blake Corrigan." He said the name with the careful neutrality of someone placing it precisely. "I know that name. He appeared before me twice in the 90s, early in his practice. He had a tendency to build his case around the client's worst instincts rather than their best interests." Harold looked at him. "He is not a bad lawyer. He is a lawyer who has never learned the difference between winning a proceeding and winning a situation." "The emails make that clear," Solomon said. "Your grandfather used to say that the most dangerous instrument in the law is a man who knows enough to construct a trap, but not enough to understand that he's also inside it." Harold folded his hands. "Corrigan has put himself inside this one in writing. That is a gift. Don't waste it." Solomon drove back to the firm and spent the following afternoon with the forensic accountant his firm retained for complex estate matters, a precise man named Gregory, who said very little but produced documentation that said a great deal. The full accounting of the unauthorized transfers was itemized, recoverable, and cross-referenced against Blake Corrigan's known communication dates. 3 of the 4 transfers corresponded to dates within 72 hours of an email from Corrigan advising Angela to accelerate the consolidation. The pattern was, in Gregory's language, consistent with coordinated intent. In any language, it was the same thing. Priscilla reviewed the completed package that afternoon and circled the coordinated intent language. "This changes the scope of the bar complaint considerably," she said. "We are no longer describing a single document. We are describing a practice." Solomon nodded. He let that settle where it needed to. By Thursday evening, Solomon was home, eating dinner with Angela, answering her questions about his week with the same even attention he had always brought to conversations that required more care than they appeared to. She had made chicken and a salad with a lemon dressing he preferred. She spoke about a property listing she was working on. She asked whether he was tired. He said he was fine. He thanked her for dinner. She had no idea how prepared the ground was. He did not raise his voice. He never did. Preparation was the work. The rest was only the Tuesday she chose to make her move. That Tuesday came 9 days later. He was in his home office at 8:15 in the evening, reviewing documents, when he heard Angela on her phone in the bedroom, her voice low and specific in the way it was when she was speaking to someone whose attention required calibration. He did not move. He heard the call end. He heard her walk to the kitchen. He heard, 11 minutes after that, the particular silence of a house whose occupant has made a decision. She appeared in the doorway of his office. She said that she needed to tell him the marriage was over. She said she had retained an attorney and had been advised to take certain steps. She said she did not want this to be difficult. He looked at her with the same expression he brought to every legal matter that required him to see clearly what was in front of him, rather than what he had wanted it to be. He said, "All right." She left the doorway. He heard her make a second call. 18 minutes later, there was a knock at the front door. Solomon set his pen down. He stood. He walked to the door and opened it. Officers Paulson and Okafor stood on the front porch in the even-tempered manner of officers who had assessed a call before responding and were not certain what they had. They asked for his name and the address. He gave both without hurry and invited them to the porch if they needed a moment. Officer Paulson, the senior of the two, asked whether there was a disturbance at the residence. Solomon said there was not. Officer Okafor said they had received a report of an erratic individual. Solomon said he understood, and that he was happy to stand there with them for however long was useful. Then Officer Paulson looked at his screen again, looked up, and said, "Sir, are you Solomon Garrett? The Garrett Law Group?" Solomon said he was. Paulson stepped back from the doorway. He turned partially away and made a call. Solomon stood on the porch. Angela had moved to the hallway behind him. She was visible in the periphery of the doorframe, still and watchful. Paulson returned to the porch after 90 seconds. He said, "Sir, I apologize for the interruption. The watch captain passed me to Chief Oaks. Chief Oaks asked me to relay that his office has been trying to reach you for 3 weeks regarding some property transfer documents, the precinct building lease renewal. He said he understood you were unavailable, and he wanted to know if you'd be willing to schedule a time this week for the signing." He paused. He also asked me to apologize for any inconvenience and to say he hopes everything is all right. The officer stood on the porch of the man whose deed they reported to work under every morning and waited. Solomon said, "Please tell Chief Oaks I will call his office first thing tomorrow. I have the documents on my desk." "Thank you, sir," Paulson said. Both officers looked, briefly, at the hallway behind him. Then they stepped off the porch and walked to their vehicle without any additional comment. Solomon closed the front door. He did not look at Angela. He walked back to his grandfather's desk, sat down, and picked up his pen. Behind him, the hallway was completely quiet. The formal proceeding took place 8 days later at the Garrett Law Group's conference room on the 6th floor of the firm's building. A room Solomon had used for 40 negotiations in 12 years, and knew the acoustics of well enough to understand what silence in it meant. Priscilla had arranged the table. Solomon sat at one end. Priscilla and their litigation counsel sat beside him. Blake Corrigan arrived with Angela at 9:15. Corrigan wore the composed demeanor of a man who had structured this kind of meeting many times and believed he controlled the terms of it. He did not control the terms of this one. Priscilla placed the printed email chain in the center of the table first, then the bank transfer documentation, then the prenuptial agreement with the relevant provisions highlighted in yellow, then the bar complaint she had formally filed with the Tennessee Board of Professional Responsibility 4 days prior, citing the manufacture language from Corrigan's own emails and the prior admonition as grounds for a pattern of conduct review. Corrigan looked at the bar complaint. The composure he had walked in with underwent a specific, visible reorganization. Priscilla said, "The prenuptial agreement is uncontested and fully enforceable. Mrs. Garrett is entitled to the marital home and the settlement amount specified in the agreement. The firm assets, the trust, and all associated holdings are premarital property under full protection." She looked at Corrigan. "The unauthorized transfers from joint accounts are recoverable and will be included in the settlement offset." Angela said nothing. Corrigan said he would need time to review the filings. "You have the documents in front of you," Priscilla said. "Take the time you need." Corrigan looked at the bar complaint for a long moment. He turned a page. He turned it back. The composure he had walked in with had not disappeared. It had simply become the composure of a man managing new information rather than executing a plan, which was a different thing entirely and visible as such. Angela looked at Solomon for the first time since they had sat down. She said, "Solomon, I want you to understand, this was not supposed to go this way." He said, "I know." He said it without warmth and without harshness, as a plain confirmation that the sentence she had begun had arrived at its only available ending and did not require more from him than that. He said, "I understand." He said it with the steady, complete evenness of a man who had done his understanding elsewhere, at the right pace, at the right desk, and did not need to complete it here. He looked at Corrigan. He said, "You wrote the word manufacture in a client communication. Counselor. My grandfather used to say that the man who holds the deed holds the conversation. You handed me the deed." He gathered his folder. He stood. He buttoned his jacket and walked out of the conference room without looking back, and the door closed behind him with the settled sound of a matter whose foundation had never been in question. 10 months later, Solomon Garrett signed the 4th Precinct lease renewal and capital improvement authorization at his grandfather's oak desk on a Tuesday morning in January. The same desk he had carried up 2 flights of stairs the day he moved it from the South Main office, the same surface he had worked at for 11 years. He executed the document with a fountain pen his grandfather had left him, pressed the notary seal, and set the folder in the outbox for delivery. The Garrett Law Group had added 4 municipal clients in the preceding quarter. The firm's managed portfolio had crossed $11 million in assessed value. Priscilla had hired 2 associates in October and had plans for a third. The bar complaint against Blake Corrigan had proceeded to a formal hearing. The Tennessee Board issued a 60-day suspension in November, with probationary conditions that effectively ended his ability to practice family law in the state. Angela settled per the prenuptial terms, without contesting the forensic accounting. She received the marital home and the structured amount the agreement specified. She relocated to a smaller house in Cordova within 3 months of the proceedings closing, which Solomon learned through a mutual acquaintance who mentioned it in passing. Her mother, who had sent Solomon a brief note after the proceeding, did not appear to have continued speaking to her with any regularity. He had met Lenora through the 4th Precinct lease transaction itself, a city planning administrator who managed the municipal property side of the agreement, and who had sent 3 precise, specific questions about the capital improvement scope before their very first phone call, and had listened to all 3 answers fully before asking anything else. They had been building something carefully for 6 months, at the pace that careful things require. One morning in February, Solomon arrived at the firm before anyone else, the way he had always arrived, the way his grandfather had always arrived, and sat at the oak desk in the early light and looked at the 3 framed surveys on the wall and drank his coffee without any particular urgency. He thought about 2 officers on a porch, asking him to call the chief about some documents. He thought about his grandfather's voice in a small office on South Main Street, patient and certain. The man who holds the deed holds the conversation. Everything else is just noise. He set his cup down. He opened the day's first file. He was free. He was clear. He was still holding the deed. I hope you enjoyed that one. Be sure to like the video and subscribe so you don't miss the next story. I've picked out 2 more for you that I think you'll really like.